Hello and welcome to the SCC Online series. Today we will be talking about dispute resolution clauses in contracts, and we'll go through them, go through how they work and what you should be thinking about when you negotiate them. So my name is Lise Alm. I am Head of Business Development at the SCC. I've been with the SCC for about 2 years, working with digitalization matters and innovation and our business development. I have a background as a lawyer, although I should admit from the outset here that I am not a litigation lawyer. I'm actually an M&A lawyer from training. And I've spent most of my time in M&A and the tech and startup sector. So I worked for a number of years at Spotify as an in-house counsel, and then I worked at other startups as well. So my perspective is actually more the in-house counsel perspective than it is the litigation lawyer perspective. That said, I am joined today with Mathilde, who is a legal counsel and who's worked at the SEC and just went back to the law firm of Hannes Snellman. And she's going to be able to help me with any questions that are more specific when it comes to the litigation aspect of it. And I will be focusing on aspect which comes to the in-house counsel perspective for negotiating these clauses. So I'm going to start with letting you, Mathilde, say hello and introduce yourself a little bit as well.
Hi, everyone. As Lisa said, I was previously a legal counsel at the SCC, but is now back at Hannes Snellman, where I work as an associate in the dispute resolution group. So hopefully I might be able to answer the questions relating to that.
Perfect. And as I said, please mute your mic if it's on. I don't think anybody has it on right now. And if you want to ask questions, we highly encourage it so that we can make sure that we tailor this to what you actually want to listen to. Use the chat function. You'll find it in your little tools bar on the in the screen here. And you can post any questions there and we'll feed them in throughout. And as I mentioned as well, we are recording this, so it will go live on the platform, on the SCC website afterwards. So without further ado, what we are going to be talking about today, let me just make sure that I have, is we're going to be presenting the SCC a little bit, and then we're going to go through the main part of today's session is to go through the various components of the clause. And it's often called the midnight clause because nobody thinks about it prior to midnight. And I must admit, as a in-house counsel, this was usually the time I thought about it as well, if at all. It is at the end of the last page of every contract. And that is usually where it is from a mental focus point as well. It's not, if you're not a litigation lawyer, it's usually not where you focus when you do negotiate a contract. And even though I work at an arbitration institute, I wouldn't be able to tell you that that should be where you focus either. Usually it's what you're buying, when you're getting it, what the quality and so forth should be. And this kind of comes towards the end of it. It is quite important though, and there are some things to bear in mind. So that's what we're going to go through. So that's the components of the midnight clause. And then we're going to have a couple of things you may want to avoid, and then finish off with a few things to remember. So this presentation, we will send it out to you afterwards. The intention is that you're going to be able to use this presentation also a little bit as a checklist for some of the aspects that you may want to look out for when you do this negotiation. And as I mentioned, you will be able to access this information also online afterwards. Okay, so Mathilde.
Yes, let's start with a short presentation of the SCC. The SCC was established in 1917 and is a part of, but independent from, the Stockholm Chamber of Commerce. The SCC is one of the most frequently used arbitration institutes worldwide, and in the recent years, the number of cases filed with the SCC, both domestic and international, has increased with up to 200 cases per year. And looking at the past 10 years, approximately 50% of the SCC cases involve at least one international party. And in a typical year, parties from between 30 and 40 countries plead their cases before the SCC. Countries such as Russia, China, Germany, and our Scandinavian neighbors tend to be represented among the top each year. The SCC has different sets of rules, whereas the arbitration rules and the expedited rules are the most common ones. The expedited rules are used for disputes of a simpler nature and are in general speedier and more cost efficient. The SCC also provides for the mediation rules, which are used when trying to resolve the dispute amicably. So let's move on then to the core components of a dispute resolution clause, or as Lise said, the midnight clause. The first thing you might want to consider is whether the dispute should be resolved through court proceedings or arbitration. And the differences and the possible benefits of the two will be explained in the next slide. If you choose arbitration, you should also consider whether the dispute should be resolved ad hoc or as an institutional arbitration. And also these differences will be explained more by Lise in a short while. When it comes to the seat of the arbitration, this is often considered as one of the most important concepts in arbitration law because it determines the law of the arbitration contract, or in other words, the law governing the arbitration procedure. The selection of the seat also determines where you may appeal an award, as well as the process and rights relating to the enforcement of an arbitral award. The seat also indicates other aspects relating to the interpretation of the clause and whether or not the matter in dispute is even arbitrable. Because, for an example, in some countries, there are laws which restrict party autonomy, and therefore the matter in dispute might not be arbitrable if that country's law governs the arbitration procedure. When it comes to the seat, you should also note that it determines the location of the hearing, but it should not be confused with the venue of the arbitration, because the arbitral tribunal may, together with the parties, decide that the hearing, or the venue, shall be conducted in a different place than the seat of the arbitration, maybe because of cost efficiency reasons. But if the venue is changed by the arbitral tribunal and the parties, the seat, and therefore the law governing the arbitration procedure, will still remain the same. If the arbitration clause refers to institutional arbitration, you should also specify which institution should administrate the dispute and also which procedural rules should apply. And there are many institutions throughout the world, and it might be difficult to choose, but Lise will soon give you a short introduction to the leading ones, and hopefully that will help. The choice of law decides on the material law, in other words, under which law the contract should be interpreted and the dispute resolved. Swedish law, for an example, is preferred in many disputes since it's considered to be predictable and neutral, and also because it has a strong tradition of freedom of contract. Swedish substantive law is also available in foreign languages, which makes it easier to apply in international disputes. When it comes to the language to be used in the proceeding, this is also significant to include, especially in international arbitration, since it might affect the party equality and also the composition of the arbitral tribunal. As you understand, the tribunal needs to know the language to be used in the proceeding. And as a final tip, when considering which components to add in the dispute resolution clause, please have in mind that the more precise and clear your dispute resolution clause is, or the more core components that you add, the less room there is for disputing the arbitration clause, and therefore delaying the procedure and maybe in the end the resolution of the dispute. However, there is a fine line on whether or not a too precise clause in the end might lead to further disagreements between the parties. But we will get back to this later in the presentation when we give you some tips on things to avoid.
So one thing to just underline here is the seat is really important. I remember when I was negotiating this in-house, I usually it often boiled down to some sort of tit for tat kind of negotiation. You get this, I get that. It's always what you have in a negotiation. And when you do that in this clause, sometimes it was, okay, you get to choose between court and arbitration. I get to choose between what material law we're gonna apply and so forth. In all honesty, I didn't really think so much about seat. I thought it was whether I liked to have my hearings in spring in Paris or not. And now that I've moved into this world, I realized that's actually the most important thing to hold on to. So if you do wind up, because when it comes to material law, Mathilde talked a little bit about Swedish law, but generally this is not where we're going to be talking so much during this presentation, because that depends on what the subject matter of the contract is, what you're familiar with, and so forth. However, when it comes to, and also if you choose jurisdictions that are fairly similar to yourself, so if you're a common law country or you're a civil law country, you're likely going to wind up quite similar. Seat is important to hold on to, because the result that you get out of an arbitration, the value of that is based on what seat you have. So if you are going to do the tit for tat negotiation, hold on to seat and give out on something else. So that is kind of the first really hands-on tip, is hold on to your seat. So we'll come back to what that means, because obviously there are many seats that are good. There are also many seats that are less good, and we'll revert back to that. But bring with you from this slide that seat is the main thing.
Exactly.
All right, moving on.
Yes.
And this is me, right, Mathilde?
Nope.
Yep. Okay. So when it comes to, sorry, Mathilde, this is you.
Yeah.
Yes, sorry. Guys, you're invited back behind the scenes of our confusion. Okay, Mathilde, go ahead.
Thank you. Okay, court or arbitration then. There are many reasons why parties choose to resolve their dispute outside of a courtroom. One difference is that in litigation or in a court proceeding, there are general judges appointed by the court, and the parties have no say in the selection. In arbitration, however, the parties usually decide together on the number of arbitrators and also has a say in the appointment. This means that the dispute may be resolved by experts in the field of the dispute in question. Arbitration is also considered more flexible, since the parties may decide on the procedure among themselves, whereas in litigation or a court proceeding, the court sets the procedure. Another difference is that arbitration is confidential, which is one of the main reasons why the procedure often is the preferred method of dispute resolution in international business relations, for example, to protect trade secrets and the company's image. In international matters, the strong international enforceability of an arbitral award is also a significant advantage compared to national court decisions. An arbitral award is enforceable in more than 150 countries, whereas a court decision may only be enforceable nationally or in the European Union. Also, an arbitral award is final and binding, and there's a limited right of appeal, even if the arbitrator makes a mistake of fact or law. So in opposite, in litigation, it is not uncommon for the losing party to attempt to appeal the judgment, which often then adds significant time before the litigation is complete. So arbitration hearings are therefore generally quicker than litigation, but not only due to the limited right to appeal, but also as the parties and the arbitrator have more flexibility in scheduling a final hearing, and there are also more set time limits in arbitration. And as an example, between the time difference between the two proceedings, if you take a more complex dispute in arbitration, this might take approximately 30 months to resolve. But the same dispute with the same complexity may, in a court proceeding that is appealed to and then tried in the Supreme Court, take up to 13 years. So there's a big difference there, even if you think 30 months is a long time.
And obviously that is that depends on all the facts. And in the case that Mathilde is referring to, we asked the law firms to make a comparison because we only see the ones that are with us, obviously. And it's hard to know whether you're comparing apple or pears when you're comparing cases, because all cases are individual. So this was cases that have very similar complexity, dispute value range, and so forth. And it also depends on how far does it go. 13 years included going to Supreme Court in Sweden. So you don't necessarily wind up in the Supreme Court, but it is still the case that it takes a lot longer to go through a national court. And it may seem that we are very pro arbitration here, and we're an arbitration institute, so obviously we think that arbitration is the best in sliced bread. But it isn't necessarily the choice for all disputes. Obviously, there are disputes that are better suited for courts. There are disputes where you, for instance, if you want a public ruling because you want the precedence, then you're not going to get that with arbitration. If you have a small case, arbitration is likely going to be too expensive because you have a threshold value before it kind of makes sense. So it's definitely not the case that arbitration is the best solution for every single case, but it does have there is a strong preference in the business community to use it, and these are really the reasons why.
Yes. If we go on to the costs of an arbitration, it's generally considered higher than in court because the parties are responsible for not paying only the counsels, as they do in court, but also for the arbitrator's fee and for the fee to the institution. But I will get back to the cost a bit more later on.
Okay, so if you do choose an arbitration, the rest of the presentation here is going to be focused on the selections that you need to do in the clause if you have chosen an arbitration, the arbitration over court. So the first thing you then have to do is, if you want, choose between whether you want to have it an ad hoc procedure or an institutional procedure. Now, admittedly, I had no idea what this meant before I started at the institution, and it also makes it very confusing that the word ad hoc is never used in a term, even if in a clause, even if you choose it. Ad hoc simply means that it's not administered by an institution, that the parties themselves, and often with the counsels, agree on how to handle the case, who they're going to appoint as an arbitrator, and so forth. So whereas an institution, what happens is if you want to file a suit, you come to the institution and then you say, hey, I want to activate this clause and I want to bring claims against my counterparty here. So what this then means is that, yeah, as I said, the parties administer or the institution administer. The difference between having it being party administered and not is there's a number of various differences, but one of them is that you have a schedule of costs when it comes to institution. So in an ad hoc, the arbitrators will decide their own fees, whereas if you go to an institution, it's regulated by a cost schedule. And you can actually calculate that on the website of the SCC or any other institutions. Well, most of the institutions have a list on the website where you can see exactly how much it's going to cost before you go into it. And most often it's based on a percentage of the value of the dispute. The next thing that you have is that if you are at an institution have a set of rules, the rules for the procedure, and they can include a lot of procedural tools that will help you move the process along further. Whereas if you're ad hoc, you fall back on the law of the arbitration law of the country that you're in. of the country that the seat of the arbitration is in. And they are quite often fairly bare-boned. So you don't have a lot of extra tools. And even if that means that you can then agree with your counterparty on how to do this, the base premise of this is that anytime you need to actually use this, you're in a dispute with your counterparty. So most often what we see is that the parties can't agree on the color of the sky at this point. So for them to then agree on a number of complex procedural tools can be quite hard. And that said, there's a lot of best practices. So it's at the end of the day, there are quite a lot of treaded paths, but that's a big difference between these two paths. The other one is that you have default more arbitrators, which means more cost. If you go under on ad hoc, arbitrator can rule on their own bias. So bias is a big question with the arbitrations. Is we choose experts within the field to sit on your dispute, then that might also mean that if you are in a narrow field, then the pool from which we can fish out a really relevant arbitrator can be quite small. And the question of bias is actually a very central one to make sure that we get a non-biased arbitrator. So with an institution, one of the big things that you get is that you have a neutral institution that helps rule on that. Whereas if it's in ad hoc, then the arbitrator themselves rule on whether or not they themselves are biased. You have interim measures in most institutions, definitely with the SEC. Whereas if you want to use interim measures in ad hoc, then you need to go to the courts and it's public and you're back in the same aspects that Mathilde told you about last slide. And then we have an ability to push our arbitrators in terms of timeline. We have their fee is actually can be deducted if they're not fast enough in terms of rendering a ruling or an award. Whereas if you have ad hoc, then you run the risk of the arbitrators having taken on too much work so that their schedule doesn't allow for them to be as fast as you had hoped. So those are the main differences there. The way that you choose whether you want to have an institution or ad hoc is simply to say it should fall under the rules of institution X. So it should fall under the rules of the Stockholm Chamber of Commerce Arbitration Institute, or you don't say anything. If you don't point to a specific institution, it will be ad hoc. That's the way you do it. So you don't write ad hoc, you just say, you just don't appoint a specific institution. Okay, so as I mentioned, choosing an institution has to do with choosing a set of rules. The institutions, you have hundreds of institutions around the world. Some of them are global and international, some of them are local, some of them are specialized within a specific type of dispute. It can be financial disputes, or it can be arts or sports or something like that. So it can be very niche or it can be very broad. And the SCC is a global institution that we take on all kinds of cases. We don't have a special area that is our core focus. We do have a lot of cases coming in within energy and natural gases and oil and those kind of things, but that's more tradition in terms of who happens to come here, but we ourselves take on all cases. So when you choose an institution, then you need to figure out which suits you the best. And the main differences when you choose them is obviously where they're geographically located. In all honesty, that is probably not going to make a big difference for you because you're never going to show up at their office. But it will have an effect on what legal system they act under. So you will find some differences if you go to a common law or a civil law system in terms of what type of procedural processes they are most used to, also where what their core pool of arbitrator may be, and so forth. And then you have the rules, and the rules are different from each institution. That's our product. It is the set of rules. You can find them on our web pages. In a way, I would love to say that we're all unique and different. But if either of us come up with something really good, and I want to say that the SCC does that quite often, usually it's being picked up. So there is quite a strong harmonization between the at least the big institutions around the world. In the rules, you will have the procedural tools. Again, they come with slightly different flavors, but you have with the big institutions, you have a similar set of tools throughout. The level of administrative support, that differs quite a lot. Some institutions are more what we call light touch administration, where the parties have more flexibility. Some of them are more controlled, and SCC is a light touch administration institute. That means that we can also keep our fees down a bit, and we're leaving quite a lot of decision power to the parties when it comes to how they want to conduct the process. And then we provide them with quite a lot of tools in the rules to be able to find the best process for them. The last thing that differs here, or the two last things, is time and cost. So when it comes to time, then it's fairly similar between the big institutions, with the exception of the ICC. The ICC has roughly double the time that the other institutions does, and that's because they have a different procedure towards the end, something that they call award scrutiny, which allows them to go through an award at the institutional level before it's being rendered. And that is a bit technical. If you're an in-house counsel, and you may not have to worry about that, it does mean that it's takes a bit longer time. And then there's a difference between cost. And we're going to come back to cost, because even if the SCC here is definitely quite competitive on cost, at the end of the day, this is not where you want to focus, because the cost of the institution is such a small part. And Mathilde is going to come back to that. But that is some of the differences. Now, as you see, I've listed a number of institutions here on the left, and these are the institutions that have the most cases around the world. So you have SCC, that's us. You have ICC, International Chamber of Commerce. You have LCIA, which is out of London. You have HKIAC out of Hong Kong, and SIAC out of Singapore. You also have a couple of other big ones, like CIATAC, which is from China. You have AAA ICDR in the US and so forth, but they have slightly different types of cases to some extent. We all differ on some areas here. LCIA charges differently. They charges by hour instead of on the disputed value. So I can't really compare how they charge, but my understanding is that they're slightly more expensive. Hong Kong and Singapore has a slightly stronger tie to their governments, but all in all of these are really high quality institutions, and you're gonna regardless where you're gonna wind up, you're gonna wind up with very high quality. And that goes also for, if you continue down the list that I haven't spelled out here, there's a number of other really good institutions around there, around the world. So it really is about what you need for your dispute or for your case. Okay. And
yes.
Mathilde.
Thank you. Like I said before, I was gonna go back to talk about a bit more about the costs, but because I said before that arbitration is often considered as a very expensive form of dispute resolution and a far more expensive procedure than in court. But that is not always true, because if you look at the numbers, the vast majority, about 70 to 85% of the total costs of the dispute, are generally counsel fees, and only 15 to 30% are arbitration costs, which is the fees to the arbitrators and the institution. So, if you consider the fact that arbitrations are typically quicker than in court, and also that it is a one-stop shop with little or no possibility to appeal, then you can see that you will need to engage counsel for a shorter period of time, and therefore that in the end, arbitration might be less expensive than in a court proceeding.
I should mention as well, I just want to bring back, if you do have any questions, please do ask them. You can use the little chat function, or I think there's also a raise hand opportunity somewhere in the app. But please do ask questions if you have any. All right, I'm going to move over to choosing the seat. And as I mentioned before, the seat is really important. The seat will determine the value of the award that you get towards the end here. And the key aspects you want to consider when you look at what seat to choose around the world is whether or not the first and most important thing is the state or the country need to be member of the New York Convention for enforceability of arbitral awards. Now, this is the base foundation for why you can have an internationally enforceable award at all. It's not a very high threshold to move over. I think there's 157 or so countries that have ratified this. So most of them are going to be members of the New York Convention or party to this convention. What you may want to bear in mind is that some of them have made exemptions, and some of them are quite recent, which means that they may not have a lot of experience with it yet. But generally, this is not going to be where you find any issues. The next aspect here is whether or not the national system has arbitration-friendly courts. Now, you can argue this both ways. Being arbitration-friendly here, what I mean by that is, will they let an arbitral award stand? Or do they have the ability or the competence to go in and change material aspects of the award? So how much competence, jurisdictional competence, does the national courts have to overrule aspects of the arbitration? So, as I said, you can argue whether this is a good thing or a bad thing, whether they should have this, and obviously in those systems where they have chosen to have quite a lot of freedom to do this, then they see this as a great thing. If, however, you have chosen that you want to have arbitration for the purpose that you want to have this one-stop shop and you want to have it not be appealable, then you may want to watch out for this. And another aspect is, since if you have if you do wind up in the national courts, then of course you need to have a country that doesn't have a very high level of corruption. So the reason why we talk about courts, even though you have chosen arbitration and they're not appealable, is that you can still challenge it for procedural reasons. So if, for instance, the arbitrator was deemed, you think that he or she was biased, or there's something really wrong with how the process has taken place, then you can appeal that part and say, look, I'm not going to say that they didn't read the evidence right or that the conclusion was wrong, but I didn't get my day in court. I wasn't heard the way I was supposed to be. This is not hasn't been a fair hearing. So those things you can take to a national court, and that's why you risk winding up in a court even if you have chosen arbitration, and that's why these court aspects really matter. The other thing is it's beneficial if you have a strong arbitration institute in the jurisdiction that you choose. Now, this may sound, and maybe it is, a bit self-serving since we are one of those strong institutions. However, the reason why this is important is because that usually means that the national court system has a they're quite used to dealing with arbitration. You have systems around it for it. You have strong law firms that have a lot of experience, and you have a big pool of arbitrators that are willing to work with this institution. And you have an institution that is quite used to helping you along the way and can get the top-notch arbitrators as well. So that's why that will help you get a good process. Another thing you may want to consider is the cost of representation. all of you guys that have been buying legal services know that the size of the bill that comes in is different depending on the jurisdiction that you choose. Whether this is important to you, it may or may not be, but if cost is a driver, then you may want to take this into consideration. And lastly, you can take in geography in this. As Mathilde said, the seat is not where you necessarily meet. If you want to have London as a seat, but you like Paris in the spring, then choose London as a seat and go to Paris and have your hearings. You can separate these, but it does have a usually it presupposes that you're going to be physically, if you have physical hearings, in the place where you put your seat. So if you look at all these, then there are some seats that are ranked quite high. And I've tried to take the slightly less biased way of not putting this list together myself that I'm going to show you soon, but rather going to one of the biggest law firms in Sweden and look at a book that they have compiled that lists out the various seats around the world and list the pros and cons that they see with them. So they have ranked a number of seats in the lead based on the list here on the left. So these are the seats that they have ranked. Now, as with institutions, there's a long tail here of other really good seats, but other the ones that they listed as the top one, these were the only ones that had didn't have any negatives tied to it. A couple of things to note here is that, for instance, London comes just outside this list, and one of the reasons for that is uncertainty around Brexit. So that may or may not be resolved soon, but that's one of the reasons why you're not seeing that here. And as you can see as well, when you go to, for instance, Canada, you need to decide not just on Canada, you need to decide on the actual city. And that goes, of course, for other places as well, but it matters since you have different jurisdictions. And that's the same, of course, if you go to United Kingdom or anywhere else where you have jurisdictional differences within the country. So coming up here towards actually the final bits, there are some things that you may want to avoid when you write these clauses. And one of the first ones is mandatory alternate dispute resolution clauses. So these can be clauses where you, for instance, have a obligation to negotiate in good faith or something similar to that. The reason for that is that it may be used as an obstruction by the other party if you want to go to arbitration. So you say, for instance, that you want to go to arbitration, but they don't want this to be resolved, and that is not uncommon. Then they will say, well, you didn't negotiate in good faith, so you can't go to arbitration yet because you haven't done everything that you need to do beforehand. If you have Swedish law on your contract, or if you have Swedish seat rather, then this is not going to be an issue because it's not a hindrance under Swedish law. But there are a number of jurisdictions that has these and as an actual hindrance. The other thing here that we see every now and then is a very detailed regulation on tribunal composition. So the tribunal says, or the clause says, we want somebody who has 27 or plus years of experience within construction from Chile and also a little speaks French. Now, probably you had somebody in mind when writing that, but that person may or may not be available when you actually have a dispute. And also, at the end of the day, you may dispute something entirely different than what you expected. So the easiest way is, if you have an arbitration institution involved, then leave it to them, because then we can look at, okay, what is actually needed for this dispute and what kind of arbitrators are actually available right now when you need it. Next one is certain type of multi-form clauses. What I mean by this is, if you have a net of different contracts, which is quite common, especially if you have a ongoing longer relationship with a big supplier or partner, and you tie a number of different contracts, and then something happens, which means that you actually get a dispute under several of these contracts. If they have the same clause, we can join them all together and have it all be under one process. That is very process economical, as opposed to running them as separate processes with separate tribunals and so forth. But the only way we can do that is if they are materially identical. So the best way here is if you have contracts that are tied together, copy and paste between the dispute resolution for clauses, and then that allows you to be a lot more smart when you come to a potential then dispute. Another thing here that is quite oh, sorry, I realized I talked about the wrong one. Now this is different clauses in multi-party contracts and structures. So certain multi-form clauses, what that one means is if there are, it's quite common to have to see clauses where it says for disputes below $1 million, we're going to go to court. For disputes above $1 million, we're going to go to arbitration. And this is, on the face of it, this is quite smart because, as I mentioned before, court proceedings might be much more relevant for lower value disputes than arbitration, just for the plain cost of it. And it might also be less complicated, so you don't need the specialists that arbitration offer and so forth. The challenge with this is courts and arbitration are exclusive. If you have a contract saying that you will go to arbitration, the court can't touch it. They have to throw it out and say, you have an arbitration clause, you can't come to us. And the same thing for an arbitration institute if it says court. So we're not actually competent to touch the case at all if it's supposed to go to court. So if you then have a dispute of 900,000, it's going to go to court. If the counterparty doesn't want this to be resolved, then he or she will find a countersuit of 120,000, moving it just over the threshold. That means that it's going to get kicked out of court, and you have to go to arbitration instead and redo it there. And then he takes away his claim. It falls under the limit for competence of arbitration. We have to kick it out. You have to go to court, and so on and so forth. So these can be quite tricky. So do them carefully if you want to do them. And the next one here is pathological clauses. So that is simply our way of saying really badly written clauses. So clauses that just doesn't make sense. We quite often get these clauses that are more or less a word tombola. You put down all the words that kind of sound like they have something to do with arbitration or disputes. You flip it around and you pull them out. So one that we found that was, I'm going to realize that this is going to be funnier if you understand Swedish, but I'll give it a go. And the background here is the word for dispute in Swedish is twist. So we had one saying if you get a twist, you need to go to Danish arbitration. So essentially, if you need to dance, you should go to Danish tree cutting. Now that one actually we could resolve because it's quite obvious what it meant. It's worse when it's mixed up to the point where I don't understand what the parties wanted to achieve here. And since it's based on party consent, if we can't figure out the party consent, we don't have competence. But then the courts might not have competence either. And again, you wind up in a really complicated issue. And usually we solve this, but when I sit in on our board meetings and there's these discussions on what was the actual party intention when they wrote Danish arbitration, then as an old in-house counsel, my thought is, I don't think there was an intention. I think it was 2 a.m. in the morning and they had run out of coffee hours ago and they didn't care. So that's something to avoid, obviously. And there is actually a really easy trick for all this. That the reason I'm telling you at the end of the seminar here is because I could have skipped everything we had set up until now and just say this: copy and paste the clauses from our website or the institution of your choice website. If you do that, all of the other things that we now discussed, you can actually forget. So the main thing to keep in mind here is just that all of us have written clauses that you can steal and copy and paste over to your contract. And I see here, I think we may have a question. Oh yeah, so I'll take a question here as well. Is award scrutiny done at the SCC? No, it's not. So that's for instance the difference between SCC and the ICC. The ICC, the International Chamber of Commerce, they do award scrutiny, and that means that after the arbitrator has rendered its award, then the institution will take the award, and they will look it over and make sure that it answers all the questions and that it is formally correct. They won't make a reassessment of the actual legal assessment, but they will make sure that all the T's the I's are dotted and the T's are crossed and so forth. So that is not something that we do. We trust the arbitrators to deliver it final.
I can just add that the SCC only looks at the costs for the arbitration, and also so that the key things that you have to involve in a Swedish award is added, but not a general award scrutiny.
And if there's any, I have one more slide here, but if there's any questions, please do. Can you give an example on jurisdictions where a mandatory ADR clause can be troublesome? Yes, but off the top of my head, obviously not, because all the putting on the spot, no, but I'm happy to get back to you on that if you send me an email. But I need to double check. Would you suggest for a state institution to include an arbitration clause in the commercial contract? When you say state institution, do you mean, would you suggest for a state to include arbitration clause in commercial contracts? If that's the question, then we very often see states. We actually have states as one of the parties in very many cases. So it is very common for states to use arbitration in these type of contracts. And actually, it makes a lot of sense, and maybe sometimes it makes even more sense for states, because one of the reasons you go to arbitration is because it allows you to have an internationally neutral party that resolves on the dispute. So say, for instance, that you have a contract with a foreign investor or a foreign company that is making an investment into your country, and you have some sort of contract around that. Now, the foreign investor might not want to have a dispute be resolved in your national court, especially if the contracting party is the state in and of itself. So then it's quite common for the state to have arbitration as a means for this. And actually, those type of state investor disputes, the SCC is second in the world to handle those after the World Bank. So we have we see this quite a lot. So the answer is yes. Now let's see. I got another question on the mandatory ADR clauses. So if you do want to have ADR clauses where you want to talk about that you have various steps, escalation steps, then there's definitely ways to do that. The trick is if they are mandatory. So one aspect to bear in mind is if you are on friendly terms, even if you're in a dispute, because obviously you can be, then the contract saying that you need to negotiate might not be necessary because you are in friendly terms and both of you want to resolve this dispute. If one party doesn't want to resolve the dispute, then being forced to negotiate it might not actually lead you to a better place. But that's a separate thing. When it comes to the poor technical aspect of it, it is if you have a some sort of obligation to do various steps, but at each point you can still say, I can abort this one-sidedly and move it on to arbitration, then you're usually fine. But if you have to take every step, then that can be troublesome if you want to escalate without taking all the steps. I'm going to take the last slide, and then I'm going to continue answering questions. So the last slide, just on things to remember here, is these are, if you only remember a couple of things from this presentation, these are the things to remember. One is that arbitration is internationally enforceable, which differs it from using courts. Even if courts, some of the courts within EU, you have enforceability and so forth. Arbitration is usually more cost effective than courts, even if you have a fee to the arbitrator, because it is one instance and it's faster. Use the model clauses and you can forget about the rest that we said in terms of how you should negotiate them. And seat, if you hold on to your seat when you negotiate, or make sure that its seat is something that you are okay with, that it is in a jurisdiction that you feel okay with. And you can't really go too wrong if you choose any of the top ranked institution. You're gonna get a fairly similar type of process, regardless of which one of us you go with. All right, now I'm moving on to the questions again. So is virtual hearings going on at the SCC? So the answer is yes and no, as in we know that a number of our cases currently are being handled through virtual hearings. We encourage it wherever it's possible. And it is under, if you have Sweden as a seat, or Stockholm, for instance, as a seat, then it is generally in keeping with the right to be heard to have it virtual as well. That said, the SCC as an institution doesn't have a specific tool that we offer for these virtual hearings. So that is often happening then via Teams or Zoom or whatever virtual hearing tool that they are using. But yes, we do have a lot of virtual hearings. We actually have had a panel on this. We've had several, but one of them in English that you can see on our SCC Online Series video tapings that is on our website. Has there been a tendency to have a higher rate of successful challenges on arbitrator for bias under, for instance, the IB? Oh, let's see here. Okay, so we have a question on the rate of successfulness for challenges for bias between the ICSID rules and the IBA rules. And I am sorry that I'm going to have to take a pass on that one. I actually, I don't know. I'm turning to Mathilde. Do you know on the questions on Nedeva?
No, sorry.
So if there's any questions here that we don't know the answer to, and as you can tell there are, then please do send them through to us afterwards, and we'll see if we can find their answer with one of our colleagues. And you can see also an article on escalation clauses that Robert Rhodes has written, that you can email him for a link. So anybody that wants to go deep on that question, please do email him. So that's thank you so much for that shout out and tips, Robert. I think I have covered most of the questions. Please let me know if there are any other questions that I have not covered. I will be sticking around for a few more minutes, but other than that, this actually brings us to the conclusion of this seminar today. As I mentioned, in a few days or so, this will be coming up on the website, so you're more than happy to check in there. And we will be sharing the presentation that I held. We will be emailing it out to everybody that has signed up for today's session. So I want to thank you all for joining us today, and I hope you have a good day and you stay safe out there, all of you.
Thank you, everybody.
Thank you.